Four U.S. Supreme Court cases caught my attention, and they're of interest to employment lawyers. One involves arbitration, in which the court said that a last mile driver is exempt from the Federal Arbitration Act. Flower Foods brings its products in from out of state and puts them in a warehouse. And then Angelo Brock is a franchisee. He picks up the product and delivers it to local stores. And the court held that he is a worker in interstate commerce, and so he's exempt from the Federal Arbitration Act, even though he never crossed state lines and he never touched a vehicle that crossed state lines. And then we have an arbitration jurisdiction case in which case was filed in federal court. The court ordered arbitration. Arbitrator issued an award. And then the question was when the parties want to either affirm that arbitration award or vacate the arbitration award, does the federal court retain jurisdiction, or do we start the process all over again? And the court said, no, don't worry about it. The court had jurisdiction. The court still has jurisdiction. And then we have a couple of cases involving the president's power to terminate the employment of people on various commissions and boards. One case involved the Federal Trade Commission, in which the president fired one of the commissioners, and the Supreme Court said that this was totally legal because of the separation of powers, even though the statute says that that person can only be fired for cause. It's a presidential power. But over at the Federal Reserve Board, which has a completely different and unique history and structure, the court said that a member of that board can retain her job while her case gets processed through the court system, and it's likely that she'll be entitled to some sort of notice of what the charges are against her, some opportunity to reply to those charges. So thank you for watching.